Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina Ma, and today's topic, when does benchmarking cause antitrust anxiety? The use and misuse of competitors' data. Whether through trade associations or other means, many industries routinely use data collected from multiple competing companies for the purpose of developing price, cost, or other performance benchmarks. But when do such benchmarking activities raise antitrust concerns? In this episode, we explore the benefits and risks of collective participation in benchmarking programs, particularly in the current era of heightened antitrust scrutiny and enforcement. Joining me today is my co-host, Alicia Downey. Hi, Alicia.
Hi, Christina.
What are we talking about today?
Today we have with us guest John Delacourt, the General Counsel to an international trade association and co-chair of the Antitrust Law Section's Trade, Sports, and Professional Associations Committee. So I want to welcome John Delacourt to the show. Hi, John.
Thanks for having me.
Before we begin, just a brief bio. John is the Chief Legal Officer and Vice President, Global Initiatives at the Plasma Protein Therapeutics Association in Washington, D.C. After getting his law degree at Harvard Law School, John spent 5 years in private practice in New York and Washington, D.C. He then joined the Federal Trade Commission, where he served as Chief Antitrust Counsel for the Office of Policy Planning for a little over 4 years. After a few more years in private practice, he joined the PPTA in 2010. So tell us a little bit about the PPTA and what you've been doing there for the last 11 years, John.
Okay, well, PPTA is a trade association that represents, on a global basis, the manufacturers of plasma protein therapies. So what are plasma protein therapies? They are drug products that are manufactured from human blood plasma. So someone goes and donates plasma in a process that is similar to, but in important ways different from donating blood. And those donations are collected and turned into products that can treat a variety of illnesses. So I think, some of them are really obscure, but some are, I think the two that are probably most familiar to people are primary immune deficiency, which is the boy in the bubble disease. If there were no plasma protein therapies, individuals with this disease would have very limited lives, but with appropriate treatment, they can live a normal lifespan and not be confined or limited in their activities. And then the other one is hemophilia. Blood clotting factors are also a plasma protein therapy, and so someone who's appropriately treated with blood clotting factor can again lead a normal life and not be limited in their activities. So, but that's the 411 on PPTA, and then what am I doing there as their chief legal officer? Well, PPTA is an industry association. We represent competing companies, and I think for purposes of today's call, the most important thing is that we operate an information exchange, a data program that provides distribution data on plasma protein therapies, so in different product classes, and we do that both in the U.S. and in Europe.
And that's going to be important, I think, in the context of today's topic, which is benchmarking. And just so people are clear, what kind of activities, fall under the umbrella of benchmarking? What are we talking about?
Well, at the highest level, benchmarking is comparing how your business is doing against industry data and performance metrics. So you have these general standards out there, and then you want to compare yourself and see how are you doing. Then you can evaluate efficiency and other factors. So, if you had 3 accidents last year. Is that good or is that awful? You don't know unless you have some benchmark to compare it against. Or, similarly, it might be, you're using 20% recycled material. Is that terrific, or is that, well below the industry standard? So benchmarking is a way to evaluate your performance. And I think we'll get into this in a little more detail, but one of the reasons that it has there's so much antitrust interest in this activity is that, there's the question of where this data is coming from that you're measuring yourself against. And it usually, this is where you run into the issue of information exchange among competitors and how that is conducted and how the information is used.
Okay, and so the antitrust concern then with the information exchange, is that any different depending on whether an association like yours is involved or if the companies do it directly with each other?
Yes. So, I think as a general antitrust counseling principle, you would want to limit the direct exchanges of information that companies have with each other, particularly if you have few players in an industry. And both the Federal Trade Commission and the Department of Justice have put out guidance in operating information exchanges. And again, this is just agency guidance. It's not in a statute. It's not a judicial opinion. But there's a strong recommendation in there that those information exchanges should be operated by third parties such as trade associations.
And what kind of information is of concern?
Well, that's an important question. Obviously, you've got more antitrust concern if you're dealing with some of the competitively sensitive information, such as output or pricing information, cost information that has a direct influence on pricing, that sort of thing. You can also have, I use the examples of how a company is doing with respect to safety standards or how they're doing on the environmental front, trying to be kind of a green organization. And I think there's significantly less antitrust concern when you're talking about those areas, but nevertheless, those may be areas in which companies compete. So there is some antitrust concern.
And who is usually initiating these benchmarking activities? Is it the industry participants themselves? Are there third parties that do this as their full-time job? Is it the market participants asking a third party to do it? How does it come about? Who's really driving it?
Well, there's a whole range of answers to that. I think I think many times it is kind of initiated by the industry participants themselves, and that is often when the main goal of the benchmarking is really to assess performance and enhance efficiency and that sort of thing. But it can be initiated by others. And for example, to use the PPTA information exchange, it really wasn't initiated by the companies. It was initiated by requests from the Food and Drug Administration. So there was a time when there was a shortage of plasma protein therapies in the late 1990s, and the food and safety regulators were very concerned that there was no data available to say, is this a short-term problem, long-term problem? Is this a slight dip? Is this a significant decline? And so they asked the industry to come forward with a solution to that by providing data, and that was the kind of the origin of the PPTA distribution data program.
And then just in terms of the output of a benchmarking exercise, after the data has been collected, what are some of the ways that the company-specific information is shielded from disclosure to competitors?
Yeah, no, that's really the essence of the guidelines that were put out by the Federal Trade Commission and the Department of Justice. And so, interestingly, they were not focused, broadly at first. They were actually published in 1996 in the healthcare statements, although they've come to be applied in all circumstances in all industries, not just in healthcare. But there's a number of important principles that are set forth, and really what the FTC and DOJ guidance does is it provides a safe harbor. It says if you do these things with respect to your information exchange, then you should be free from antitrust scrutiny. And so there's such things as having a third party operate the data program as opposed to the competitors themselves, or ensuring that the information is historic. That is, you don't have current competitively actionable information, but you have rather information that's at least 3 months old. And there's also a big concern about the transparency of the information. So there are standards there, the big one being that there must be at least 5 contributors of any numerical value that's provided. And that way it's more difficult to work backwards and say, what is each individual company's contribution?
And does competitively actionable information, as you put it, necessarily always involve things like prices or terms of sale, or perhaps wages and salaries, which is another area where I know the agencies are concerned about oversharing?
I think that's the area of greatest concern, right? When you're in those areas of price and output or salary information. There have been a number of cases. DOJ and FTC have really focused on kind of these human resources types of concerns. And not too long ago, there was the Detroit nurses case, which involved hospitals that were kind of providing information about the wages that they were providing to nurses and providing that through surveys. And then the allegation was that was used to kind of put a cap on wages or wage increases. So that would be the most significant concern when you're dealing in those traditional areas where the antitrust counselor's radar kind of perks up. But there can be concern in other areas. I mean, as we talked about at the outset, even if you're dealing with something that may be more of a reputational interest, such as companies wanting to appear to be the most virtuous with respect to being, green and environmentally friendly. It doesn't immediately spring to mind that there's an antitrust concern with sharing data about that, but companies compete on all sorts of different things. And, if one company, if they all got together and said, we want to be green, but not too much because that's going to impose too many costs, I think the agencies would be concerned about that.
Now, you mentioned the U.S. agency's guidance, and for anybody listening, we will post a link to the healthcare guidelines on the webpage for this episode, so you can take a look at them yourselves. What about outside the U.S.? Has similar guidance been published with respect to information exchanges and what companies or third parties, such as associations or perhaps consultants retained for the purpose of analyzing data, can and cannot do?
Yes, there is. So I think let me just explain the difference. So there is guidance that's been put out by the European Commission as well. And so, but it's very different from that which was put out by the FTC and DOJ in that it's really more of an issue spotting guide, right? So it says, whereas the FTC and DOJ guidance will say things like, you must have at least 5 companies participating. The European Commission guidance will just say, data must be genuinely aggregated. So it's really getting at the same issue, but it isn't providing kind of the same clear standards. And again, the FTC and DOJ guidance says, the data should be no more recent than 3 months old. And the European Commission guidance is more just saying, the data must be historic. It doesn't get into how many weeks or months old it needs to be. So there are pluses and minuses of both. I think as a company, you might like the greater flexibility that's provided by the European Commission guidance. But I mean, on the flip side, I think the FTC and DOJ standards provide more certainty. And honestly, I think when you're dealing with kind of multinational corporations that need to comply with both the European Commission guidance and the FTC DOJ guidance, I think they tend to default towards that FTC and DOJ guidance just because it is more specific.
Now, there have been, I believe, instances of various types of emergencies or other exigent circumstances, like the cyber attacks in the last few years, and of course, the global pandemic that have been, perhaps a reason to allow greater information exchange among competing companies, so that they can address some of these situations. Is that something that you see happening more frequently, or is that something that's written about in the guidelines, or is it all very ad hoc sort of exceptions to the rule?
Right. Well, I mean, that's where you come into the fact that these are guidance, right? They're not firm and strict requirements. So by laying out these standards, FTC and DOJ are saying you'll be in an antitrust safe harbor. But if you're outside the safe harbor, that doesn't necessarily mean that you are in the territory of an antitrust violation. I think what it does mean is that if you're outside that safe harbor, you need to have a story to tell. You need to have a justification for why you are outside that safe harbor. And that's where the emergency context that you mentioned, I think that could be extremely significant, right? So one of the things that the agency guidance is designed to do is to limit transparency, right? That you have these aggregate data figures and it's not clear what each company submitted, or you have kind of older information that kind of gives you a feel for where things stand, but it's not up to the minute. Well, if you're worrying about how many vaccines are out there, or you're worrying about is there going to be enough personal protective equipment to deal with the COVID-19 pandemic, maybe it makes more sense to have more recent data, or maybe it makes sense to have more granularity with respect to what individual companies are doing. So that's the type of thing where you're in a gray area, and I think that emergency circumstances definitely play a role.
Yeah, and companies who are facing these scenarios can get an advisory opinion, from DOJ with respect to these types of collaborations, and I think that they have. So you can point to that as precedent. I think I want to talk about a slightly different aspect of benchmarking. We've been talking about more or less legitimate, activities that the industry and others perceive as beneficial and pro-competitive for various reasons. But what happens when companies manipulate benchmarks such as a price index, or such as what happened with the LIBOR rate indices? They know what they're doing. They're doing it intentionally to gain a benefit. And so, there have been some extensive class actions in this area and some government enforcement. Is that something that, also needs to be kept in mind? If you're the counsel to one of these groups, that all might not be as it seems.
Yes, no, I think that's a great point. And you really need to be focused both at kind of the front end and the output end, right? So if you have an information exchange, you want to make sure that you want to be asking yourself, how is that data being used? Is it being used in an appropriate way to maximize efficiency and to make companies better competitors, or is it being used as a kind of a signaling mechanism that allows them to restrict output? And by the same token, you need to look at the front end, and that's where you get into these cases like in the financial sector. It wasn't just LIBOR, but others where these interest rates are kind of established through whether it be surveys or by looking at actual transactions, there's a formula for establishing what that rate will be. And that creates an opportunity for manipulation, that the contributors to that survey or those who are generating the transactions can work together to report their information such that they achieve a benchmark that they want. And that certainly raises anti-competitive issues and has spurred litigation in the past.
I guess, John, could you talk a little bit about what liability looks like in this space? Is it criminal? Is it civil? Is it against individuals, the companies? And one thing that you raised, which is of interest to me, is let's say you have 5 folks who are contributing to the benchmarking, but 2 are really engaged in anti-competitive conduct, and the other 3 are just contributing and haven't necessarily participated. How, are they liable? Are they on the hook?
Yeah, no, it's a great question. And, where you have, you may have companies that have a bigger influence on the benchmark as well, right? You have companies that are different size, or they, in a different product market, they may have a greater market share. So I think all those factors weigh in. I mean, I think with respect to, criminal versus civil, it's going to be whether there's evidence of intent, right? So that's if you're dealing with companies that are well counseled, that's going to be extremely difficult to find, right? You're not going to have the juicy emails or, recorded telephone calls where people are talking about the fact that, hey, let's get together and get this interest rate in the direction we want, or, so-and-so is clearly from the data we've seen, they need to be kind of brought back in line. So it's really, I think, an evidentiary matter. But the one part you didn't mention was the trade association. That's kind of my concern, is that as a trade association counsel is you've got companies that are participating in different levels, but you also have the trade association that can be have a concern that there'll be a claim that they facilitated some sort of collusion or price fixing arrangement. And at PPTA, that's why we've taken an additional step. I think when the DOJ and FTC guidance, when they're talking about a third party, they're really meaning anybody besides the competing firms themselves. So a trade association itself could be the third party that operates in information exchange. But the way our association handles it is we have so much interaction with our members. We work with them on lobbying activities, and we work with them to press their interests before, health and safety regulatory authorities like the Food and Drug Administration, and we organize industry conferences and things of this nature, that the PPTA staff and our member company personnel are always working together. So there's this concern that, well, while the individual companies provide data to PPTA, can't PPTA then turn around and kind of, at the water cooler or at the bar at some industry conference, kind of let everybody know what the individual submissions are? To avoid that concern altogether, we work with a third-party data aggregator, and I think a lot of trade associations take that additional step just to have that security.
And thinking about how, many trade associations in industries have had, long-standing data collection and, market research type of work and benchmarking work. But over the years, the industry's become more and more consolidated. And so the question arises about whether the information, their output, is becoming more and more antitrust questionable as the number of players is reduced. The claim can arise that, everybody, despite there being, the information's masked or aggregated, it's still all too clear, whose data is whose. Do you see that as being a potential danger in industries that are subject to more consolidation?
Yeah, no, that's definitely an issue. And when there are I think that's always a concern from a collusion perspective. It's easier for a smaller number of players to collude than for a large number, and that makes a huge difference in the trade association context or in the information exchange context generally. If you've got 1,000 participants in an information exchange, the idea that any one or two companies can kind of manipulate that benchmark is remote. On the other hand, if you've got, say, 3 or 4 companies participating and, one of them has an overwhelming market share, then it may be very easy to kind of reverse engineer any aggregate figure and determine which, what contribution was made by each individual player. So, that's a question I deal with all the time in the association is, people come to me and say, why can't we as PPTA do X? Because I see some other association is doing that on their website or at their conference or whatever else. And, the difference is for PPTA, our membership consists of 6 large global manufacturers, at least at the global level. We have other tiers of membership, but that's very different than an association that has 25 members or several hundred.
Great. Well, that's been super informative. Thanks so much.
Before we let you go,
I know there's more.
We do like to ask all of our guests a few questions. So, John, if you could tell us something interesting about yourself that we wouldn't know about you if we only knew you professionally.
Right. Well, can I qualify it by, I will tell you something about myself and I will leave it to you to judge whether it's interesting or not, right? So, yes. So what I'm going to use is, I have, I will say this, even for an ABA audience that is very cosmopolitan and very well traveled, I like to think that I have traveled to some obscure locations that others may not have gone. So I'm going to list a few of them. So I've been to the Galapagos Islands, and my wife and I traveled to Romania, which is kind of off the beaten path. And then another example would be the Russian cities of Suzdal and Vladimir. So those are a few of the examples.
I don't think I've heard of that one. So when things open up, where are you and your wife going to go next?
Where are we going to go next? Right now, so we have kids now, so so it's a little bit different, and they've really been pushing that they want to get out to the national parks. So I think that would be great, and I think that's an opportunity that maybe would open up in the short term, as opposed to some kind of exotic foreign travel, which is, I think, maybe a longer term enterprise, given where the pandemic is.
I think RV sales and rentals have skyrocketed during the pandemic. So certainly encourage you to jump on an RV and do that national park tour. That sounds like fun. And John, what advice do you have for students or younger lawyers looking to do what you do?
My advice there would be to try and get a perspective on the bigger picture. So, what I mean by that is, I think when you start out, particularly if you're at a law firm, which is a beginning position for many lawyers just coming out of law school and just getting started in the practice, is that your role is really to work on some tiny fragment of a big case or a tiny fragment of a big transaction. And just getting your head around that tiny fraction can be such a preoccupation that you're working with your nose to the grindstone to get that done and to understand it and meet the deadlines, et cetera, that you don't take the time to understand what the whole case is about or what the whole transaction is about. And so I think there's some advice there on the flip side as well for the older or more seasoned lawyers that you should try proactively to provide that information to the younger colleagues, maybe realizing that they're looking for that guidance and wouldn't necessarily be inclined to do that on their own initiative right from the beginning.
That's great. And it's interesting, right? Since you've pivoted from a more specialist role to something more of a generalist as counsel in-house, any advice for folks moving from being strictly antitrust counsel to being a more generalist counsel and how to navigate that career shift?
Well, I think it's definitely a change of focus. The biggest thing for me has been, and even now I bristle at it a little bit, is when you're a law firm, doing more law is always a good thing, and that's not necessarily the case when you're inside a company or a trade association. When there's new legal work coming in the door, that is not necessarily greeted as a welcome development. I think that's kind of being able to look at the business perspective, which, of course, I mean, even if you're a law firm, you want to understand your client's business very well in order to serve them effectively. But I think it becomes more of even more so a top line priority when you're in-house or at an association.
Okay, well, John, now for our final segment, what we call the Curious Hat.
And now it's time for the Curious Hat.
So, John, in normal circumstances, we would actually have a physical hat. You'd pick a number 1 through 25 out of the hat. Obviously, I don't have a hat here with me. So, John, could you just pick a number, say a number 1 through 25?
Okay, 24.
24.
Good number.
Go high.
So, John, this is quite appropriate. What is your favorite warm weather activity?
My favorite warm weather activity, even more so, again, I mentioned that I have 2 daughters. My favorite warm weather activity is biking. So, now that it's springtime here in Washington, I'm ready to get back out there. My daughters are old enough that they're ready to keep up with me and get out there on the bike trail. So, I would put that as high on my list.
So you're more of a trail rider than like I don't know what they call it, like a road rider.
Well, I guess it is a trail of sorts, but it's kind of a rails to trails thing, and so it's paved, and it's very it's very user friendly for the novice.
And do you have a Peloton?
I do.
Outdoor biker. You're like no indoor biking, just outdoor biking.
Right. No, I do have a bike, but I have to say, an exercise bike but it doesn't get a lot of use.
Well, John, thank you again for your time today. This was very informative, and for all those listening in, thanks for listening in today, and we'll talk to you next time.
Thank you for listening to this week's episode of our Curious Amalgam, a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law Section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust.